Hello. Welcome to Educate at Finleaf. What is a contract? The Indian Contract Act, 1872 is the statute regulating and controlling contract laws in India. Section 2H of the Indian Contract Act, 1872 defines contract as an agreement enforceable by law. It is a promise enforceable by law. Essentials of a contract: offer and acceptance, mutual consent, consideration, competence, legal purpose. Let's compare a contract and an agreement. First, a contract is a formal arrangement between two or more parties that is enforceable by law. On the other hand, an agreement is an arrangement between two or more parties that is not enforceable by law. Second, for contract as well as for an agreement, mutual acceptance by both, or all, parties is necessary. Third, both the contracts as well as agreement does not need to be in writing, except for some specific kinds of contracts, for example those contracts that involves lands etc. Fourth, consideration is required in a contract but not in an agreement. Fifth, the contract is legally binding and its terms may be enforceable in a court of law. Whereas an agreement that lacks any of the required elements of a contract has no legal effect. What is an offer? Section 2A of the Indian Contract Act, 1872 defines proposal/offer as when one person signifies to another his willingness to do or to abstain from doing anything, with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Every contract starts from an offer. Without an offer there can be no acceptance. What is an acceptance? Section 2B of the Indian Contract Act, 1872 defines acceptance as when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. Once the offer is extended, it is in the hands of the offeree to either accept or reject the proposal/offer. Let's understand types of contracts. Contracts on basis of formation. First, express contracts. The contracts are made by the use of words or are written. Express contracts include written and oral contracts. Second, implied contracts. Contracts made by the use of gestures or actions are known as implied contracts. Contracts based on performance. First, executed contract. Executed means the contracts which have already been performed or done. Second, executory contract. An executory contract is a contract that is yet to be performed. Third, unilateral contract. A unilateral contract is a one-sided contract. Fourth, bilateral contract. A bilateral contract is a contract in which both parties exchange promises to perform. Contracts on the basis of validity. First, valid contract. A valid contract is a contract in which all essential elements are present. Section 10 of the Indian Contract Act defines the essentials that are needed for a valid contract. Second, voidable contract. According to Section 2I of the Indian Contract Act, 1872, an agreement which is enforceable by law at the option of one or more parties but not at the option of others is a voidable contract. Third, void agreement. According to Section 2G of the Indian Contract Act, 1872, an agreement that is not enforceable by law is said to be void. Fourth, void contract. Void contracts are contracts which when originally made were valid and binding on parties but eventually become void due to some circumstance. Fifth, illegal agreements. An agreement against the public policy or violates rules against public policies is called an illegal agreement. Sixth, unenforceable contract. An unenforceable contract is a contract that cannot be enforced in a court of law because of some technical issue or glitch. Contracts based on duration. First, full-time and part-time contracts. A full-time contract usually involves 40 hours of work per week, and it may go up to a maximum of 60 hours per week. A part-time contract generally takes around 30 hours per week. Second, fixed-term contracts. A fixed-term contract is set for a stipulated period within which the set task must be accomplished. Third, agency staff contracts. This contract deals with hiring employees on a temporary basis from agencies which provide services for larger corporations. Fourth, zero-hour contracts. This type of contract deals with workers who can be contacted for professional service but they are already working for some other employer. Memorandum of Understanding. A Memorandum of Understanding is said to be an agreement which needs to fulfill the valid requisites of a contract under Section 10 of the Indian Contract Act, 1872. When two or more parties agree to work towards a common objective, without a legally binding contract, a Memorandum of Understanding or MOU is created. Essentials of Memorandum of Understanding. First, parties to the agreement. Second, purpose of the Memorandum of Understanding. Third, duties and responsibilities. Fourth, time period. Fifth, confidentiality. Sixth, scope of the transaction. Seventh, indemnification. Eighth, financial implications. Ninth, conditions for alteration and termination. 10th, restrictions. 11th, dispute resolution. Now let's learn the difference between Memorandum of Understanding and a contract. A MOU in general is not legally binding or enforceable. On the other hand, a contract is always legally enforceable. A Memorandum of Understanding do not normally require the realization of conditions such as an offer, acceptance or a valid consideration. Whereas a contract always involves an offer, acceptance and a valid consideration. Memorandum of Understanding are always written, and a contract can be both oral or written. MOU are not always registered, whereas contracts, if written, are registered and all legal formalities are satisfied. Please download our mobile app from Google Play Store. You can also follow us on LinkedIn, Instagram and YouTube. Thank you for watching. In case there are any questions, you can write us at info@finleaf.in. www.finleaf.in